So 3 ATF bump stock ban cases are now set for Supreme Court consideration at the end of this month. So let's talk about this. But real quick before we jump into this video, if you think these types of ATF rules are clearly unconstitutional and violate the Second Amendment, go ahead and hit that like button and subscribe. Also want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they are huge Second Amendment supporters. They have dedicated roasts for organizations like FPC and GOA. So if you buy one of those roasts, some of the proceeds go directly to those 2A organizations so they can file lawsuits. So again, amazing coffee. You can check them out using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, in this video, we're going to be talking about the ATF's bump stock ban in 3 cases, which are now distributed to the Supreme Court for consideration. As many of you know, we recently received a major Second Amendment decision which came out of the 5th Circuit en banc panel. The 5th Circuit en banc panel ruled in a case called Cargill v. Garland, and in that case, the ATF's final rule on bump stocks, which banned bump stocks, was in fact found invalid. This decision struck a major blow to the ATF's current overreach and also their claimed authority to put in place these types of restrictions. Now, in this important decision, the 5th Circuit en banc panel found that the definition of a machine gun as outlined in the NFA and GCA does not apply to items like bump stocks. Now, after that Cargill case, there was also some other cases, one of them being the Harding v. Garland case, which was out of the 6th Circuit. And in that case, in the 6th Circuit, the court issued a similar decision voiding the ATF's bump stock ban, but came to the conclusion using a different type of rationale. Then there was also the Guides case, which was out of the District of Columbia. And in that case, the court found that the ATF's final rule was in fact valid, so they sided with the ATF. Now again, similar cases deal with a similar issue, but they came to different conclusions and they used different rationales. Now 3 of these cases and all 3 of these decisions have created a circuit split, which is now up for the Supreme Court for review and has been distributed to the Supreme Court for conference. These cases have major implications not just for bump stocks, but also they will likely impact other ATF rules like their rule on frames and receivers, and then also their pistol brace rule. Now, for those not aware, the primary case Cargill involved a direct challenge to the ATF's rule, which suddenly regulated and banned bump stocks under the assumption that those items were now magically machine guns. For many years, the ATF had stated that the NFA and GCA's definition of the term machine gun does not include devices like bump stocks. However, after the incident in Las Vegas, them being directed by President Trump, the ATF arbitrarily decided to change their regulatory definition of machine gun so that now bump stocks are magically considered to be machine guns. One of the important aspects of this challenge was whether or not Chevron deference should be given to the ATF in relation to this rule on bump stocks, or whether a different rule called the rule of lenity should be used and would ultimately direct courts to rule in favor of us the people, not the ATF. Now, if you're not aware of what Chevron deference refers to, Chevron deference is a term coined after a landmark case, which refers to the doctrine of judicial deference, which is given to administrative actions. Generally, for an agency like the ATF to be given Chevron deference, the agency's interpretation of an ambiguous statute must be rational or reasonable. So when a statute has ambiguous terms, the agency responsible for enforcing that statute may be able to determine what that term was intended to mean as long as their interpretation is rational or reasonable. In contrast to Chevron deference, there is something like the rule of lenity. The rule of lenity indicates that when dealing with a criminal statutory interpretation, the court is required to apply any unclear or ambiguous law in a way that is most favorable to the people, not the enforcement agency. Now, in a 13-3 decision, the en banc panel in the 5th Circuit found that the ATF overstepped its authority in regulating bump stocks as machine guns under the GCA. The court in that opinion stated that a plain reading of the statutory language paired with a close consideration of the mechanics of a semi-automatic firearm reveals that a bump stock is excluded from the technical definition of machine gun set forth in the GCA and NFA. In the decision, the 5th Circuit en banc panel clearly identified that the definition of machine gun in the GCA and NFA does not include items like bump stocks. And even if the term were considered ambiguous or vague on that issue, the court concluded that the rule of lenity would direct them to interpret that ambiguity in the favor of the people and essentially find that bump stocks are not machine guns. Now, if Congress, they said, wanted, or the ATF wants that definition to include those items, then they need to change the statute, but the ATF does not have the power to do it all on their own. Now, in one of the other cases, the Harding 6th Circuit case, the 6th Circuit came to the same conclusion, but they used a different approach. In the 6th Circuit Harding case, the court started from the position that the term and the statute is ambiguous on whether or not the definition of machine gun would include items like bump stocks. And so they started from that position of the term being ambiguous. They then decided to clear up that ambiguity by using something like the rule of lenity. And again, those two different decisions, the Cargill and Hardin case, came to the same conclusion, but they used different approaches. Then you saw the Guides case out of DC, where the court there in DC argued that there was no ambiguity, but that the text was very clear that these types of items were covered under that definition of machine gun. So you have three different cases, three different decisions. Two of them reached the same conclusion, used different rationales, and then you have the DC court, which came to a different conclusion. Now, after the Fifth Circuit issued their decision in the Cargill case striking down the bump stock ban, the ATF decided to file a writ of cert up to the Supreme Court, essentially asking for the Supreme Court to review this issue. In their petition, the question the ATF puts forward for review is whether a bump stock device is a machine gun as defined in 26 U.S.C. 5854 subsection B, because it is designed and intended for use in converting a rifle into a machine gun, i.e., into a weapon that fires automatically more than one shot by a single function of the trigger. So in these cases, both sides are asking for the Supreme Court to grant cert, to grant review on this issue. Both sides argue that there is varying decisions and multiple circuit court opinions on this very topic. And one of the interesting things with these requests is the fact that the ATF now argues against adding the consideration of the rule of lenity, because they argue that the question they presented to the Supreme Court would cover that topic, but the court does not need to expressly include the consideration of the rule of lenity. And all of this is now coming to a head, and it's coming to a head at the end of this month. The Supreme Court has distributed all three cases for conference on October 27th. That means that at the end of this month, the Supreme Court will consider if they want to grant review or deny review to these cases. Now, for those not familiar with Supreme Court conferences, what this means is that this case was sent to the court and they will get together on that day and decide what they want to do with this case. Do they want to grant review to this case? Do they want to deny review? But also these cases could be rescheduled for a different conference date. That's already happened a couple times in this case, on the Cargill case, the Guides case, the Hardin case, and also there have been other bump stock cases that have been to the Supreme Court, have been denied review from the Supreme Court, but really there is no case that has been better situated than the Cargill case, because again, that's a Fifth Circuit en banc panel decision, which struck down the ATF rule and their regulation on bump stocks as machine guns. So really right now, the Supreme Court kind of has their hands tied a little bit in maybe having to review at least one of these cases. Traditionally, after the conference the following week, you will then see an order list from the Supreme Court, and the order list will identify what cases the court has granted review to, and then also maybe which ones they denied review to. In my opinion, it's going to be very hard for the Supreme Court to not grant review to at least the Cargill case, especially because how it's procedurally postured and kind of the split in opinions that's going on right now with the varying courts. Again, also the Sixth Circuit decision. So it's going to be really hard for the Supreme Court to avoid this. I wouldn't say that it's 100% that they're going to grant review, but I think a lot of people, especially in the two-way space and in the two-way field, are anticipating that the Supreme Court will grant review to at least the Cargill case because of how the Fifth Circuit en banc panel decision was in that case. And if the Supreme Court denies review, then that becomes precedent, at least in the Fifth Circuit. Again, all these cases are very important. These cases are going to be huge, potentially to stop the current ATF overreach in regards to other issues like frames and receivers, pistol braces, force reset triggers. And again, all these have been distributed to the Supreme Court for conference, and hopefully we'll have a clearer view of what the Supreme Court wants to do with ATF overreach by the end of this month. So 3 critical Second Amendment cases against the ATF are now up for Supreme Court conference, and if we get any more information, I will let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.